Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. In this edition, we talk about wills and estate planning for members of the AFL-CIO. I'd say in these difficult economic times, I'd say more and more companies are scaling back and sometimes hurting the working people. But it's not a time where union members should not think about doing their estate planning and having their important documents done. Let's see, as average Americans, we work 80,000 hours in a lifetime. I'd say often 45 to 55 years. In spite of the resources that people accumulate, a house and other assets, most Americans don't take the time to think about doing a will. Too often people wait until they're sick in the hospital, sometimes when it's too late to do a will. Let's say, so in the absence of a will, let's say there's substantial additional expenses that the family has to go under. Let's see. So for example, if someone doesn't have a will, the union member's assets go to whomever state law says receives the assets, or to the government itself if there are no immediate family members. A will should be a statement of the things you truly care about: spouse, children, your parents, your friends, your charities. If you leave no will, or your will is declared invalid because it wasn't properly prepared or is not admissible to probate, let's say number one, people you dislike or people who dislike and ignore you may get your assets. 2. State law determines who gets your assets, not you. 3. Additional expenses will be incurred and additional work to qualify as an administrator, a surety bond, other court costs, and legal fees. 4. You lose the opportunity to try to reduce estate tax, state inheritance taxes, and federal state taxes. Let's see. And let's see, you should also know that if there's no will, let's see, then I'd say it often causes fights and arguments amongst the family. Now, let's see, we all often say, well, why does someone need a will? To see if someone is not, let's see, sick or old. Well, you do planning ahead of time. People plan their vacations. They don't take enough time to plan for their estate. Now, what are some of the clauses that you want to have the attorney put in the will? 1. Debts and taxes to be paid. 2. Specific bequests, if there's any specific items you want to go to a family member. 3. Disposition to spouse, or sometimes no disposition to spouse. 4. Disposition of the remainder of the estate. 5. Creation of trust for spouse. Sometimes you don't want them to get the money outright. 6. Creation of trust for children. Same reason. Sometimes you don't want the children to get the money outright because they'll blow it, spend it on liquor. You want the money sometimes to be used for education, support, but not be spent. Same thing for grandchildren. Don't let the grandchildren get any money outright until they're at least 21. 8. The will shall have a clause setting forth who would be the executor. 9. Will should set forth, if there's going to be any trustees for people to hold the money. And 10, for guardians. Guardians are the ones that would raise any minor children. And 11, make sure that you have the attorney prepare a will that has a clause that says no bond is required. Now, even if someone has a will, periodic review is essential based upon the marriage, death, birth of people named in the will. Sometimes people's assets are high. In New Jersey, there's estate taxes on assets over $675,000. So sometimes we discuss ways to try to reduce assets. Now, in addition to having a will prepared, there's other documents that my union member friend should have done. Number 1, power of attorney in the event someone becomes disabled. Let's see, also a living will. Let's see, if someone, it takes the pressure off family, if someone's in a hospital, they're in a coma, irreversible condition, giving instructions to hospitals and doctors what they want. Now, having a will and power of attorney are not documents that typically cost thousands and thousands of dollars, but it is an investment. And if there is no will, typically to have to spend money to go to court to have someone declared by a judge to be an administrator, the fees are in excess of $2,000. While having a will, usually a regular will would cost in the neighborhood of about $3,000. So you're really saving money. For additional information on wills and powers of attorney, go to website njlaws.com. That's njlaws.com, or call the law office of Kenneth Vercammen, 732-572-0500, or 1-800-NJ-LAWS-7. They're at 2053 Woodbridge Avenue, Edison, New Jersey. Thank you, and good luck.